Hi, and welcome to this latest immigration law update video. In this video, I want to look at the question of entry clearance, Article 8, and meeting the immigration rules. And to do this, we're going to look at a recent decision called Asma Begum from the President and the Vice President. The citation is 2021 UKUT 115. And the simple situation is this: what happens in a case where the maintenance requirements, the financial requirements, are met at the relevant date specified in the rules? That's the 6 months prior to the date of application, but wouldn't be met at the date of the appeal. Well, the first tier tribunal judge thought that the appeal should be dismissed, but the upper tribunal finds that actually no, the appeal should be allowed because the Secretary of State can't point towards the maintenance of immigration control when the rules are met at the relevant time, and there are no other reasons why the appeal should be dismissed. Let's have a look at the head note. So in an application for entry clearance as a partner under Appendix FM, the financial requirements in E-ECP.3.1 regarding income from employment relate to the period of 6 months prior to the date of application. There is no requirement to continue in the relevant employment or some at least equally remunerative employment thereafter. So the significance of P being found by the tribunal to satisfy a provision of the immigration rules, which the Secretary of State did not consider P to satisfy and caused the application to be refused, applies equally to in entry clearance cases as it does to where P is in the United Kingdom. That is, the Secretary of State won't be able to point to the maintenance of immigration control. So in other words, head note 2 is a simple way of saying if you meet the rules at the requisite time, the decision is disproportionate and the appeal should be allowed. Although look at head note 3, there may be circumstances in which it would be right to refuse even though the rules are met, if there were an extreme case such as a forced marriage, or if there'd been something like deception, for example, on public policy grounds. I suppose, you know, we've seen that in country in terms like where there's been a TOEIC allegation or where there's been a tax discrepancy allegation, that even though the rules are met, there might be countervailing reasons why the appeal should nevertheless be refused. So Bangladeshi national, married to a British citizen husband. The immigration rules are set out from Appendix FM, the financial requirements in E-ECP.3.1, which are referred to in the head note, and then the specified evidence from Appendix FM SE. The decision of the respondent was only on financial grounds, only matter in issue. The Secretary of State had argued certain documents had not been provided. There was the classic refusal saying, well, we tried to contact your employer, but we couldn't get in touch. There was also a credibility issue about why would he employ you in a business that uses volunteers. It was accepted that it was a human rights appeal because obviously a refusal of a partner application would be a refusal of a human rights claim. Came before Judge Gibb on the 17th of May 2019, and on the 24th of June 2019, the judge dismissed the appeal. The judge, look at paragraph 9, and his paragraphs 16 and 17 are quoted. The judge found that the sponsor was not a clear witness, but the judge had clear evidence about his previous employment that was unchallenged, so evidence from HMRC, the employers, or all these documents and Companies House. So the judge made a finding on the balance of probabilities that he had been genuinely employed as claimed, and the sponsor was earning over 18,600. The judge said, I was not invited to make any findings as to the sponsor's financial circumstances at the date of hearing. It was accepted, having recently become self-employed and set up his own company, he was not in a position to provide any documentary evidence to establish his income. So at paragraph 10, the president records that the judge had decided to dismiss the appeal because it was a matter of considerable concern that all this time and effort had been focused on countering the refusal reasons, but it hadn't been addressed the current position at the date of the hearing, and seemed to be critical of the representative, saying they'd missed a glaringly obvious point, that successfully countering the refusal would not lead to an outcome in the appellant's favour where the sponsor no longer met the financial requirements by the date of hearing. And the judge goes on to say, even in the days when there were appeals that focused on the date of decision, so sort of pre-2012 appeals, it was still the case that entry clearance could not have been granted if the relevant circumstances had altered following the date of decision. The judge says, well, you might feel a sense of injustice, but you haven't established the current position. So he dismissed it on Article 8 grounds and found there were, even though an appeal could succeed, even where the rules are not met, this was not a case where a submission had been made to that effect in this case. I'll pause at this stage. One concern about this case I have is, even though the upper tribunal's findings are very helpful, what I don't want judges to be saying is, well, you didn't meet the rules at the date of application, therefore I'm just going to dismiss the appeal. You may still be able to argue that if you now can show the financial circumstances, there would be reasons why the decision would be disproportionate. So I think that's still open to you. But what is helpful about this case is the upper tribunal are very clear that if you meet the rules at the date of application, because that's what the rules set out should be the correct date, unless there are some serious reasons otherwise, the appeal should be allowed. The worrying thing is the first tier tribunal and the upper tribunal refused permission to appeal. The grounds challenged the approach of the judge and pointed out that Appendix FM focused on the 6 months prior to the date of application. And effectively, the judge had written something into the rules, a requirement that was just not there. Fortunately, there was a successful CART JR, and often we see the tribunal's decisions criticising sort of CART JR applications, but this is one where its importance is there because Mr. Justice Mostyn was concerned that a remedy had been denied in this case. So certainly it stresses the importance of the CART JR procedure. So the president says, well, there can only be two reasons really why the first tier tribunal judge would have been entitled to reach such a decision. The first is if the rules require you to show not only employment at the date of application, but also that employment had carried on up to the date of hearing. And in that scenario, if the rules were not met, the only way you could succeed by showing that the decision is disproportionate outside of the rules, and no reason had been advanced on that basis in this appeal. The second basis for the judge would be that if there were reasons that even though the rules were met, the decision was still a proportionate interference with Article 8. Now, they say that the judge, paragraph 22, it was clear he based it on the first of those reasons. He thought that the immigration rules had an ambulatory character. That means that you needed to show it up to the date of the appeal, a forward-looking character. The judge quotes that, well, even in the pre-2012 days, the rules still had a forward-looking character, and you had to show there would be adequate maintenance. And they say, well, is this still the position? They quote Mahad and the need to interpret the immigration rules on their plain, ordinary meaning. They go through E-ECP.3.1 and say the immigration rules clearly point to the evidence being required relating to the 6 months prior to the date of application, or in certain circumstances of employment, 12 months preceding the date of application. And they stand in contrast to E-ECP.3.4, where in terms of accommodation, you must provide evidence that there will be adequate accommodation. Now, paragraph 27 of the immigration rule says the respondent will decide the application in the light of the circumstances at the date of decision. So in terms of accommodation, if the position has changed prior to the date of decision, the respondent would be entitled to refuse on that basis. But certainly in terms of the financial requirement, it's clearly wedded to that 6 months period prior to the date of application. And they draw quite helpfully an analogy by with the points-based system and the way the courts have been at pains to sort of set out the clear requirements in the rules. And it's not for the immigration judge to rewrite the rules effectively in those circumstances. So they find the judge was wrong to dismiss the appeal on the basis that the appellant did not meet the requirement of the immigration rules at the date of hearing. But they say, though that error would not be material if the appeal would still have been dismissed for the second reason they gave in paragraph 21 above. What was that second reason? Well, was there another reason for finding that the decision was still proportionate? Now, they go through the case law of Charles, Lebanon, OA, and TZ Pakistan. Probably the two I'll look at is OA and TZ. OA, the president pointed out in that case, where the rules are satisfied, the Secretary of State can't point towards the maintenance of immigration control in the proportionality balance. Or more clear in TZ Pakistan, where a person satisfies the rules, as long as Article 8 is engaged, that would be positively determinative of the appeal. Now, they note that those were concerned with in-country cases, but say, well, it applies equally to entry clearance. Now, they acknowledge there may be circumstances, paragraph 36, that even where you meet the rules, it still may be proportionate because of some reason, such as, say, a forced marriage or some deception issues. But there were, of course, none present in this case. So this case falls squarely within OA and TZ. And the fact the immigration rules were met in that relevant period, which was the 6 months prior to the date of application, meant that the decision was disproportionate and entry clearance should be granted. It's interesting, actually, within the decision, just finally, they do point that the Secretary of State has the power to cancel entry clearance at the port of entry if there's been a change in circumstances. They refer to this at paragraph 26 and 27 and refer to paragraph 3.1a of the immigration rules. Obviously, that's the old version of Part 9 of the immigration rules. The new version of Part 9, I've just put that on your screen now, has a similar provision at 9.20.1, where there's been a change in circumstances since entry clearance was granted, or 9.20.2, where the person is seeking entry, their purpose is different to what they specified in their application. So those are the new provisions providing for cancellation on arrival within the new Part 9, as opposed to what was cited in Begum. But Begum is a very helpful decision in terms of, if you can show the financial requirements were met at that date of application, unless there are other reasons for finding the decision proportionate, your appeal should be allowed, because the rules would otherwise be met and the Secretary of State can't point to anything in terms of the maintenance of immigration control. I hope that's helpful. I'll put the links below this video.